we will have a session tomorrow on democracy majoritarian. So the topic of today's discussion is the emerging challenges in Indian constitutionalism. So after studying the topic in very detail, the previous 13 topic, so the modern discussion are equally important to be discussed in relation to the changing political scenario or changing the judicial approach. So these two topics are quite relevant. And to discuss the topic with us, we have Sanjit Chakraborty, sir. He is Assistant Professor of Law at NUJS, Kolkata. Sir has been in the academic profession since 2005. So sir has more than 15 years of academic experience with him. And I hope we will get from sir. I welcome you, sir, on behalf of Society for Constitutional Law and Human Rights, and I invite you to make your presentation.
Thank you very much. Should I start, Ashutosh? Okay. A very good afternoon to all of you. First of all, I must express my thanks to my colleague, Mr. Ashutosh, and to all other committee for giving me this opportunity to share my thoughts on this particular topic. Now, for today's discussion, the topic is the ideas of constitutionalism and emerging challenges in India. Now, I hope all of you have at least about the working of the constitution and the constitutional law, and more specifically, the necessity or the relevance of having a constitution in a country like India. Divide this particular topic. Actually, there are two things in this particular topic. One is the ideas of constitutionalism, and another portion of the topic is the emerging challenges in India. I will try to explain the idea of constitutionalism. This particular, whether he or she intentionally choose words, that is the ideas, but yes, it is true. Itself is an idea. Okay. Now, I will try to the ideas of constitutionalism from different perspective or the different dimension. And then I will rather seek your opinion that according to you people, what are the emerging challenges? And on the basis of that identification, I will again start my discussion to relate these particular challenges from the idea of constitutionalism. So, in the meantime, if you have any question, if you want to comment, obviously I must welcome all of you to raise your issue during the discussion. I have no problem. So, if we look the very basic idea of constitutionalism, actually, I want to start this particular discussion with a very simple observation, that is law. And I think all of you have read this popular magazine that Ubi society is EV juice. There is a society, there is some law. And this particular law exists, or rather the society, particular legal system in a very organized manner. Though the term law or the discipline of law is pure science, but yes, law can be understood or law can be studied, and each and every political society get into the discussion of law with a very particular objective, that is justice. Now, what is justice? What are the criteria which are to be fulfilled through the mechanism of law? These are quite relevant questions. But enter into the discussion quite in details. Let me tell you this particular point, that the academicians, except Professor Upendra Bakshi and very recently Professor MP Singh sir, and to some extent Professor Ishwara Bhatt, among the academicians, these people are trying to elaborate the concept of constitutionalism from Indian context. Among the writers, even if you go through the Indian books, there are very few. It is only H.M. Srivai, T.K. Top. Very recently, in the recent edition of the books, that is the Shorter Constitution of India, by Durgadas Basu, you will find a little mention, or rather I must say a piecemeal mention of the idea of constitutionalism. Instead of the fact that a discussion of the constitution presupposes that there is some sort of constitutionalism, because unless and until we do have the constitutionalism, having a constitution, it becomes quite meaningless. Now, constitution, if we look into the perspective, if we look into the theoretical perspective, that is law as a priori concept. That means a thing taken as it is. Okay, it is a normative science. Okay, and constitution is nothing but a document which codifies certain norms as the basic norms, or the norms which cannot be violated, or that is the norms through which all other norms are to be tested. It has been very rightly discussed by John Finnish in book The Natural Law and Natural Rights, that a country may have a legal system, but that particular legal system, it must be accepted, it must be acceptable by the people of that particular society or that particular state. Because if you have the legal system, but the legal system is not being followed or not being obeyed, that is, the state is making the law, state is passing the law, or the legislature is passing the law, but the law is not being obeyed or being followed by the people for whom it has been made, obviously it will be, quote unquote, a less legal system. It cannot be termed, or it cannot be treated as a perfect legal system. Now, the work of law, the functions of the law in a society is to ensure justice, and it is quite irrelevant for any legal system to look into the the different types or the characteristics of the society, because the lawyers are just like the physician, the medical practitioners. The task of a medical practitioner is to treat the disease of the body, or to treat the disease which exists within the body. Actually, he is not very much concerned about the body itself. Rather, his main task or her main task is to treat the disease which exists within the body and restore the body in its earlier condition, that is free from any sort of disease. Now, the discussion of law, it is very much related with justice. Now, justice, it has many facets. Justice, the idea or the discussion of justice started long back with the writings of John Finnish. And if we look into the different stages of development, you will find that the of justice, for example, the idea of justice as it was propounded or developed by John Rawls, it was an ideal concept of justice. Every person will be equal, all of them will enjoy equal rights, etc., etc. But subsequently, if we look into the modern approach, the contemporary writing about justice, if we look into, for example, the idea of justice by Amartya Sen or Martha Nussbaum, okay, the butterfly of politics in her books. If you look into this particular concept of justice, that they adopted the capability approach. Now, obviously, I am not here to discuss what justice is. For my discussion, it is quite relevant to give at least an acceptable definition of justice. For that particular purpose, I can conclude for the time being that though the term justice, it is multidimensional, has different meanings, or the justice can be achieved through different ways and means, but justice needs to be ensured according to law. Even very contemporary writings on justice, it has been mentioned that the statutes are the repository of justice. Because maybe many of the law, for example, if you try to understand this particular aspect, that for many of us, even the death sentence in rarest of the offenses amounts to injustice. But so far the justice is concerned, it is to be ensured in accordance to the law, and that is why the death sentence is allowed. What I'm trying to say, that any particular act of the state, because all of us, we have accepted, how I will discuss it later, a little later. We have accepted that the state is the only authority which can prescribe or pass the sanction against me or the individuals or the person within the particular territory. Now, justice is to be ensured, and justice is to be ensured in accordance to the law. And obviously, here the law, it has a very limited meaning. That is, the law means the law as it is, not the law as it ought to be. Obviously, academic discussion, it is always be there in relation to what the law ought to be. But in a country which is governed by a written constitution, and when the lawmaking power has been expressly divided between the state legislature and the central legislature, that is the parliament and the state legislature, then in that case, the law ought to be this particular concept that gets any sort of validity unless and until it is so accepted by the legislature, or unless and until it is qualified as a law, obviously by virtue of a customs or by virtue of a precedent. Now, when society, we talk about the society, we always talk about the society which is very much a normative one. That is a normative society. And this normative society, it is based upon norms. It is based upon norms. And law itself is the normative science. As I already mentioned, that law is not a pure science based on unchanging and the universal truth. Actually, law is always changed, and the law is very much different from one to another state, from one society to another society. The time, place, all these are the determining factors so far the law is concerned. We can actually, the law sometimes, while framing the law, we have to take into consideration the reaction of the society, or it is the social reaction. For example, in relation to any particular offense, how severe the punishment should be, sometimes it is very much based upon the societal reaction. I can give you a very recent example. But very few days back, the Bangladesh Parliament came with a law for giving death sentence to a person who is guilty of offense of committing rape by way of ordinance, because there was a huge public protest, and ultimately the government was compelled, to bring in this particular punishment, whereas so-called the developed countries, they are trying, or they are taking the initiatives to abolish the death sentence. What is my point here? That the reaction, in relation to any particular act, or in relation to any particular commission, it differs from one society to another society. Not only the the discussion law be confined only with the act or omission. Even the people's aspirations or the people's demand is very much different from one society to another society. For example, the term women empowerment, or for example the personal liberty, it is it has some sort of different meaning in India, and for example it has a different meaning in some other developed country or European countries. So ultimately the point is that we are living in a society, okay, before, and obviously we are living so-called modern state, quote unquote. And if we go back historically, I think all of you know about the social contract theory, Hobbes, Locke, and Rousseau, because the contribution of Hobbes in relation to constitutionalism, or the development of constitutionalism, is very much important. And at that point of time, that is before entering into the modern state, people used to live in a state which was known as the state of nature. And in the state of nature, obviously that particular society, in the state of nature, it could not be termed as a political society, because there was no norms, settled norms. according to which the members of the societies must act. Now, when we entered into the modern state, by virtue of a general will, or that is the contract, we accepted to a particular systems of norms. I intentionally termed this particular society as a normative society. That means the society which is based upon the norms. Now, the law itself is norms, that if X happened, then Y should happen. Okay. Now, this X and Y, in that case, the Y, it is quite variable. For example, if you commit the offense theft, you will be punished. As per section 378 of Indian Penal Code, the punishment which may extend to 3 years. But for the same offense, the punishment may be different in some other country or in some other society. So here, if X happened, then Y should have this Y, this particular Y concept. It is a little bit variable. That is why law is not a pure science. It is not a mathematics. It is not like 2 plus 2 is equal to 4 and it is equally true into the entire world. The matter is not like that. As an example, I have given here, that is, that H2 plus O is equal to H2O. That means 2 atom of hydrogen and 1 atom of oxygen under prescribed pressure and temperature will produce water. And this is a scientific formula. This is a scientific formula. And this scientific formula is equally applicable at any place in the world. You can produce the same thing by following the same formula. But by applying the same law, you can't attain the same quality and the quantity of justice throughout the world. So, the law results from a continuous striving to develop a workable set of rules that balance the individual and group rights of our society. Now, this is a very preliminary discussion. That in order to actually, in my experience, I have seen that we directly enter into the discussion of law, and after that we discuss justice. But so far I can understand, if we can relate law with justice at the very beginning, then the discussion may be much more easier. Now, as I have already mentioned, that law is a normative science, it is the norms. Now, what should be the norms? What should be the norms? In my earlier discussion also, I also, just a few minutes back, I also mentioned that the state is the sovereign authority. I think all of you have read political science, and in the political science, people have been taught the state is equal to what? A definite geographical territory, population, sovereignty, and the government. Now, here the sovereignty, obviously, the meaning of the term sovereignty, that is the supreme one, the power of which cannot be challenged. Now, obviously, within the particular territory, the government is sovereign. And the sovereignty, obviously, it must be sovereign. And the sovereignty, it is the external sovereignty and internal sovereignty. That means it is free from any sort of power or pressure from any other country outside the territory of India, or any organization or body of individuals outside of the territory or inside the territory. Now, the question is that when the sovereign authority will exercise its power, or when the authority, that is the state, will exercise its authority or the different sort of activities, either it may be executive, it may be legislative, or it may be judiciary, because these are the basically three functions of the state or the government. Here the term state and government, I am using it interchangeably. That is, there are three functions. First of all, to execute the law, and if there is any dispute, to adjudicate upon the dispute. These are three basic functions which traditionally the state performs. Now, what would be the set of principles? I want to draw attention, or rather to ask all of you people to recollect the discussion of Sir Henry Maine and Leon Doggett. That is, law cannot be made artificially. Okay, law is to be found. Okay, and it is to be codified. So, law cannot be made artificially. Why? Because in the name of law, whatever we have today, you just imagine, and if you have any question, if you contradict, if you want to contradict, you can ask me the question. But whatever we have, actually, all of us, we agreed to that. Okay, this is our general will, or it is the common will. Okay, if a person commit the offense theft, he or she should be punished. I think no reasonable human being will oppose this idea, because it is one of the very basic principles. It is one of the very basic principles. No one should be allowed to enjoy the property at the cost of the others. This is the principle, and on this particular principle, the law has been made. Now, Leon Doggett, he said that it is the popular will, that is the wall gist. On the other hand, if I give some input from the writings of Sir Henry Maine, he mentioned that the law of a particular nation or the law of a particular society, it cannot be separated from the historical fact. If we want to make the law, we must know the history of that particular society for which we are trying to make the law. Now, obviously, each and every society have a different composition, culture, everything. Every society is quite unique from one another. So, law can't be common. That is why, if we compare it with the social contract theory, actually, the Constitution, which consists of a set of rules or norms creating, structuring, and limits of the government power and authority. Okay, it is the codified norms that how the government exercise its power and what would be the authority of the government. Now, if we look into the Constitution of India, just preamble, I know all of you know it very well, but I want to read out this particular portion. We the people of India having solemnly resolved to constitute India in such and such, I am not reading the entire thing. Then I am coming to the last line. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. That means the norms which are codified, which are detailed in the constitutions, these are the norms set out by the Constituent Assembly on behalf of all of us. Though there are some doubts, there are some arguments against the functions and the validity of the Constituent Assembly, or the some author, you know, wrote some scholarly articles where they have against the adaptability of the democratic principles in the Constituent Assembly itself. But I am not entering into that discussion today, but maybe tomorrow I will enter into that discussion. But it is the Constitution, that all of us, we agree that these are the norms, and these norms are codified in the name of the Constitution. Okay, and we are giving this authority or the power to govern us, because in a state we use the term government, and the task of the government is to govern, not to rule. We are not under a ruler, and there is a difference between ruler and the government. So this is the documents, and these documents contain certain norms. Now we got the Constitution, we have the Constitution. Now what is constitutionalism? Constitutionalism, I still remember, that in the year 2018, while delivering a lecture, that is the D.D. Basu Memorial Lecture, was delivered by Professor M. Singh. He said that it is very difficult to define constitutionalism, but you can get the idea of constitutionalism, and you can also prove it a violation of constitutionalism. What does it mean? It simply means that if you have the Constitution, and if you follow the norms set out in the Constitution, these norms, the norms which are mentioned in the Constitution, these are not only between the state and the individuals. State, if I can say that it is a politically organized entity, like that, along with all its organs, that is the executive, legislative, and judiciary, then obviously they are dealing with the individuals. Now, when the government or the state is acting or working or functioning within norms set out in the Constitution itself, and they are strictly adhering to that, that idea is known as constitutionalism. That means the government can and should be legally limited in its power, and that its authority depends on its observing this limitation. Actually, this is the idea of rule of law. Okay, many people try, to discuss the idea of rule of law from the writings or from the time of Aristotle and all of these things. But this is a very old concept from the Indian perspective. That is the dharma, which echoed from the mountains of Arjabharat, which is deeply rooted into the Indian society, that no one is above the law, including the king or the queen. So, the constitutionalism is a notion, is an idea, which simply says that the individuals are to follow certain norms if they have to abide by the terms and conditions as set out in the constitution itself, then the government must follow the same route, and that is the constitutionalism. The constitutionalism, it implies a balance between the power of the government, and here the government is equal to executive plus legislature plus judiciary. It implies it actually balancing mechanism between the power of the government on the one hand and the rights of the individual other. I don't know, for example, all of you have read fundamental rights, and one of the very basic characteristics of the fundamental right is that it cannot be taken away, or the fundamental rights can even be exercised against the state. Generally, we are being told like that. We, the teacher, we say or we express the opinion about the fundamental rights in that way. Have you ever asked this question that why it is so? Answer is very simple. That at that time of the contract, I have selected some prudent men, not I. That is, for example, a society consisting of 10 people. Out of these 10 people, 7 people, they selected. Now we will say elected. They selected 3 people who are quite wise, intelligent, and we said that from today onwards, you people will govern us. Okay, but that means we surrender. Before that, we used to regulate ourselves according to our own will or wish. But through social contract, we have surrendered. Now, during this process, actually, we retained something with us. We did not surrender it. Okay, we did not surrender it. So the things which we did not surrender, which we did not give, how can you limit it? At the time of constitution, at the time of framing the constitution in India, it has not been given, or it didn't come to India from any external sources. Rather, this is a constitution prepared by ourselves. Okay, we gave the constitution to ourselves, and when we gave the constitution to ourselves, in part 3 in fundamental rights chapter, we retained the fundamental rights with us. So similarly, when we surrendered this particular authority or power to the government, we also prescribed norms according to which the government should work. Either it can be the legislature, or it can be judiciary, or it can be executive. If norms are applied to me as an individual, similarly these norms are equally applicable to the government itself. So This is an idea where not only the individual or the citizen of a country is being governed by the constitution or by the supreme norms or according to Kelson by the groom norms. Okay, because according to Kelson, it has been said that the constitution is the groom norm in India. You can challenge any other norms on the basis of the groom norm, that is on the basis of the constitution. But there is no documents which is above the constitution. And that is a priori concept, a thing taken as it is. That means maybe there may be some other documents which is far, far superior to this. Maybe. But a priori concept, the constitution is the best. It is the supreme document. It is the best document. And it is the ground norm. So you may have the constitution. For example, this is a constitution, but the executive or the judiciary or the legislature, they are not following the powers structure, or they are not following the limitations. Then it is termed as constitutional. Then we can say that we have a constitution, but we don't have the constitutionalism. But when the government limits its power, and it is a very difficult task. Please try to understand. When you have been given the power to rule someone else, then it is the expectation from the other side that you will limit yourself. You will limit yourself. You will limit your own power. And you will limit your own power in such a way so that it will not affect them quite adversely. Or it will not, it will not, it is somehow unwanted. So this is the notion. It is an idea of constitutionalism, and it is very difficult thing, because try to understand that wherever there is a power, there is a chance that someone or that particular person may misuse the power. Okay, I think all of you know the proverb said by Lord Acton that every power tends to corruption and absolute power tends to absolute corruption. Now, you have the power. Even then, you are limiting yourselves while dealing with the others. That idea is known as constitutionalism in a normative society. Now, if you make a survey of existing literature, I found that it is only the scholars from the other country, for example, the Charles M. McCowan, Howard J. Graham, or Sartori, they are the prominent writer on this particular, that is the constitutionalism. But very recently, there are two books. That is the Oxford Handbook on the Indian Constitution, edited by Sujit Chaudhary, Madhav Khosla, and Pratap Bhanu Mehta. And there is another writings, that is by Professor Bakshi, that is the outline of a theory of practice of Indian constitutionalism. This is an article, this is a particular paper published in the books, that is the Politics and Ethics of Indian Constitution, edited by Rajiv Bhargava. Now, my entire discussion is based upon these materials. Okay, I have followed, this particular materials to discuss this particular topic. Now, in order to understand the constitutionalism, there is no other way. There is no other way but to understand the different description or the approaches as suggested by the different authors from their perspective. Because as I already mentioned, or many as I already told you, that it is an idea. Now, how can I make an idea visible to all of you until I can give you basic characteristics or the effects of this particular idea? then only you can understand. So, the entire idea of constitutionalism, actually it was started during 1938 to 39 by Professor McLoin. He gave 6 lectures at Cornell University, and he defined constitutionalism as it is a limitation on the government. It is a legal limitation, and it is the antithesis arbitrary rule. Its opposite is despotic government and the government of will instead of law. Now, what do you want? In a modern democratically, do you want a despotic government? While discussing, I may give an example with which I have no political, here I have no political affiliation, and I am not propagating any political ideology. But I will give some example. For example, there is a criticism against the present government, central government, that some sort of authoritarian despotic government is going on. Okay, or it is some sort of anarchy, authoritarian anarchy. If it is false, then it is well and good. But if it is true, then I have to test this particular allegation from a constitutional viewpoint. That whether the government imposing any arbitrary rules, whether the government is trying to impose the rules which are not supported by a jurisprudential discourse, is the government trying to impose certain things or certain norms which is the belief of few people or a particular group of people or a particular community. Okay, because there is one allegation against the present government that this government is very much in favor of a particular community and against one particular community. Now, if it is so, obviously it is the violation of the constitutionalism. That means the government is under the law. And try to understand that the constitution, it has been given by to the people, by the people themselves. So there is no one. Rather, it is the people at large, we the people, quote unquote. We will decide. Now, obviously, it is not possible for a country having 130 crore of population that each of them will go to the parliament and participate in the lawmaking process. That is why we have the elected representation. Now, when Professor McLoin introduced the concept of constitutionalism in that way, that it is something by which you can limit the power of the government, okay, so that the government does not become a despotic one, he admitted, rather he reiterated, that but the most ancient and most persistent and the most lasting of the essentials of a true constitutionalism still remains what it has been almost from the very beginning, that is the limitation of the government by law. Limitation of the government by law. Who will? The government, obviously, if I have the power, obviously I will try to exaggerate it. But The lawmaking power is with the government, and here the government must limit its power by the law itself. These are the very recent book written by Andreas Sozu, and the title of his book is The Limiting Government: An Introduction to Constitutionalism. After discussing the idea of the limited government, actually why the idea of limited government came into existence, it is because of the some problem. Let me tell you that it is because of the war, civil war, and some sort of anarchism. That is the idea of constitution, that in the name of law or in the name of government, you can't do anything. In the name of law, you can't do anything. Okay. Similarly, in the name of the government or in the name of the ruler, you can't do anything. You are also under certain limitations. And in Andreas Sozo, in his book, firstly, he mentioned, at the very first instance, he mentioned that constitutionalism is the restriction of state power in the preservation of public peace. What if the government exceeds its power? If the government does not follow the rule of law, if the government goes against the principles, the settled principles of the constitution, then what will happen? Ashutosh sir, am I audible? Can you hear me properly?
I'm hearing you, sir.
Okay. So here, the public peace. Obviously, there will be some sort of unrest. Okay, the people will go against the government. And you can't maintain the peace. And whenever there is in a society, there is no peace, there is no justice. You can't ensure justice. And try to understand that the ultimate objectives of any political society is to ensure justice. But while saying so, that the state power, that is the preservation of the public peace, constitutionalism is the restriction of the state power in preserving the public peace. He admits that there is no satisfactory definition of constitutionalism, but one does not only feel when it has been violated, one can prove it. That is the thing I was telling. That the violation of this particular thing we can feel. If it is true, I am not admitting. That is the mass atrocities, few incidents which took place in the past, where a shadow has been cast upon the performance of the government in some state government, even at the center. Then we can say that it is a violation, and I can feel it. Let me give one very recent example. That is the day before yesterday, the Supreme Court cautioned the West Bengal police, more specifically the Calcutta police, in a very strict manner, that you must take some sort of precaution before filing FIR against any citizen. Actually, one girl residing in Delhi, she posted on her Facebook page something which is nothing but some sort of criticism against the state government for its failure to COVID-19. Okay. And the Calcutta police lodged an FIR and summoned her to appear before the Kolkata police in Calcutta. ultimately she went to the Supreme Court, and the Supreme Court dismissed that individual liberty, it cannot be curtailed. Okay, and you can't do anything which creates some sort of fear in the mind of the individual citizen, that if I say something which amounts to a criticism against the government, then I may be harassed. So this is a very recent example. That is, the government, that is the execution, that is the executive, the police person is the law enforcing agencies. They must also be within the limitation. Within the limitation. I was going through the dictionary meaning of constitutionalism, and what I found that Oxford English Dictionary, it says that adherence to constitutional principles. That means you have the constitution, and obviously constitution, the so many principles, so many doctrines, so many norms are there. When you are adhering to that constitutional principles, that is constitutionalism. That means as a student of constitution, you must take constitution seriously. You must take constitution seriously. It is not like that you have a constitution, that's all, that's fine. It is not like that. If you have the constitution, then you must follow the constitution and not allow any deviation, even in the face of any of other values. That is the constitutionalism. Max Weber, Max Weber, he described the things in a very illustrative manner, and he said that the state is a human community. The state is a human community that claims the monopoly of the legitimate use of physical force within a given territory. I mentioned this point in my just few minutes back. The state is a human community. Actually, this is a collective approach. Okay, but it claims the monopoly of the legitimate use, because obviously all of you know Article 21. Okay, that is the use of force. It should not be unlawful. That means the physical force. Actually, this particular description, it results from the Austinian view of law. It is the law of the sovereign backed by sign. Now, here it's a, it has been emphasized that when you claim the monopoly sometimes it results to the deprivation of the consumer's right. So, the documents, that is the constitution, it has been taken or it has been adopted. It must be applied. It must be applied even against the state who claims the monopoly over that is over its citizens. When we, as a student of law, and even the students of political science also, whenever we discuss or whenever we take into consideration the term state, actually we include ourselves within the state. But if we consider this particular aspect, that I have some sort of separate entity even in addition to the state, okay, then you can claim some sort of restriction upon the government's power. And Professor Grimm, by he tried to distinguish this state and society, that is the a group of people consisting of of individuals. That state and the society, we try to distinguish this. As a student of political science, I mentioned that the term state is equal to the territory, the population. But if I say that the state is something else and I have a claim, for example, in welfare state, all of us, we always claim against the state. What does it mean? It simply conveys the idea that an individual, the state is something else, and the state is under an obligation to provide me that particular thing. So, according to Grimm, he said that strip the society of all means of political power and set it free while the state was equipped with the monopoly power, and then restrict it. Is the difference that enabled rational binding of a state power by law. Although it regulated the relationship between the state and society, the latter held the entitled position as a matter of principles and the former obliged position. Former obligated position. That even in the next line I mentioned that that is the concept of the state has undergone a radical change. Initially, the concept of the state, it was the laissez-faire. And I am the state, I am above the law and God. Okay, this was the concept. But today, the state is a modern. We say the modern welfare state. Modern term is very much related with the politicums or the normative society, and welfare. That means it doesn't remain anymore a laissez-faire state. That means it is a state which is very much restricted, regulated by norms or by the law, according to which the people or the society as a whole are also being guided or governed or regulated. Actually, in a modern welfare government or in a modern welfare state, the state has to take care of its citizens from cradle to grave. And that is why our demand is quite high. Everything, for each and everything. Okay, for each and everything. We demand against the government. Whether we are performing our own duty or not. I just imagine the situation that, in order to remind you the duty, we have a separate provision under the Constitution that listen, this is a fundamental duty. And in many cases, the court said that whenever you are claiming the fundamental rights, you must also fulfill the fundamental duties. So if we think that India, and obviously it is not thing we I'm quite agree. I will know your opinion that India is obviously a perfectly modern and welfare state. Now there is one problem, and I think here the discussion of constitutionalism finds validity. What is the characteristics? If we look into the Indian society, or India as a whole, we have immense diversity, we have poverty, we have ignorance, and many other negative factors. Many other negative factors. Now, how the constitution will work? Please try to understand that if the people are diverse, their needs will be diverse. And when the needs or the demands of the people are quite diverse, then it is quite difficult for any of the government to the demands. And in that case, if the government fails to fulfill the demand, obviously it may bust or escape itself from any of the constitutional obligation. For example, I can give one example. That though there are some directive principles take one example, that is the Common Civil Code. Society asserts that it is acceptable. It is not acceptable to a particular community. So sometimes, as a student of the constitutional law, I can say that the state is bypassing from its constitutional obligation. Or in my class, in the constitutional litigation, when we discuss the concept of equality, when we discuss provisions relating to reservation, even it was the obligation, the state is under an obligation to review the policy regarding reservation. But maybe the vote bank policy or the vote, electoral interest is one of the reason. But the diversity of the society is also one of the primary reason or deviation from the constitutional principles. If the people are poor, you can easily manipulate their wish or will against the government. And during this COVID-19, we have seen that sometimes the government is coming with a promise, that ration will be free in this time, etc., etc. There are some criticism in the news or the media that the government has promised that we will give vaccine free Bihar election. No, can't we hold the government liable to provide the healthcare facilities for all? Because if right to life, even in my understanding, right to life also includes this free vaccination for the people who are not economically able to purchase those vaccines. Ignorance. Most of the communal violence which takes place, and it is one of the mandate of the constitution to maintain secularism, to ensure peace within the society. But I think it is the ignorance. Most of the communal violence takes place because of the ignorance, lack of education. They are fighting against each other without knowing the reason for which they are fighting. So the question can be asked, in such a situation, how the constitution will work? This is my question. This is my question. In such a situation, how the constitution will work? And here I want to take a pause, and I want to listen from you people, my students to whom I'm addressing now, that what is your opinion? I think you got some idea what the constitutionalism is. And here the question is that in such a situation when the country is facing this type of negative, factors, these are the negative factors. In such a situation, how the constitution will work? Because if you have the constitution, but the constitution is not working, you are not in a position to follow the provisions of the constitution, then you are not following constitutionalism. Okay, now here I am taking pause, and I'm just, I want to listen from you people. What is your observation? What is your question? Or what you want, or what are the problems behind with the idea of constitution at this point? Please. Any question?
Okay, so anyone of you, if you have any question, you can ask. Any observation?
At least you must tell me that, what are according to your opinion, what are the challenges of constitutionalism? Because till this point, I have the idea of constitutionalism into the theoretical perspective, because the and it is we need some. So constitutionalism, I have posed one question, that in a country like India, where these are the negative factors, I think now deny, or rather you can deny. Now if these are the negative factors, then how the constitution will work? And according to you, what are the challenges of constitutionalism?
Okay, so anyone, what do you think? What is the challenge? Any challenge which you find? Or Shikhar, anyone? Kindly ask. You can use your mic or you can type. If you don't want to ask, then you can type your question.
नहीं तो आशुतोष सर आप ही बोल दीजिए थोड़ा.
ये कुछ पूछ रहे हैं सर, ये
You just tell me that, sir, what are... Acha. Okay. It should start with the grassroots level by okay.
He's saying majority in both House of Parliament is a challenge.
And that portion I will take tomorrow.
So it should start with the
majority
grassroots level. It should start with grassroots level by providing education. So she is the education. So
education. Okay. Apart from that, sir, we used to have academic, during our stay at, what do you think, according to you, what are the challenges of constitutionalism?
Okay, for me right now, in my opinion, the biggest challenge is, I think, the people who are running, basically the criminalization of politics. I think that is going to be a big challenge, because the people who we are, every day we read this. For example, right now, yesterday I was watching. It said that almost, I think if I'm not wrong, almost 20% of the people who are going to contest election in the second phase of criminal background. So there's a conflict, because at the one end we have that a person is presumed to be innocent till the time you prove guilty. So you cannot stop him technically from contesting the election also. At the same time, technically, there is a irony that at the end of the day we are being regulated by the law which is made by people who are having criminal cases. And the reason is that the people who are going to be elected, cases are not going to be finished within the 5 years. So technically we are governed, and maybe after 5 years I will come to know that this MLA was convicted. But technically for the 5-year period, India or a particular state was having a law in which a criminal was participating. So in my opinion, that is what I think it is a big dilemma and big challenge.
Okay, sir.
Sir, Gautam here, if I can add to Ashutosh's point, because I'm from the state where even if the Supreme Court in its different ruling or the Election Commission has time and again stated, even if you are providing ticket to the people who have criminal background or have registered cases, you have there on your, so that order of the Supreme Court or Election Commission even not being followed. If you check, they are submitting it to the while they are filing the nomination. The issue regarding the availability of whether the court has instructed them to upload on the website, even that is not. So this is also a challenge where the limitation, the constitutionalism we are discussing. So that part can also be related to that aspect. That even a let down norms is not being followed. So what will happen, or is it not again will follow the contempt? There is a ruling, you are not following that. So what is going to be?
Execution of the norms. Okay, in a modern terminology, that is the law, execution of the norms or the execution of norms, obviously it's a problem. It's a real problem. And maybe it becomes so common that we don't none of the agencies, they take it quite seriously. None of the agencies, they take it quite seriously. And in the present context, if we look into this, the courts are overburdened. Okay, basically each and every matter are being court, and at many points of time, the decision of the Supreme Court or the High Court, they are giving a decision just like a khap panchayat. Okay, and it is even, and it is rightly mentioned by Falias Nariman, that is, the decision of the court must be the judicious one. It should not act just like a khap panchayat. But unfortunately, we are expecting. In the next slide, I tried to imagine, rather, I took the help of the different scholar. Took some observation from the recent case laws, and I tried to give you the example that these are the area where the principles of constitutionalism, and these are the certain problem in relation to constitutionalism. In the next slide, it would have been better if the students, they gave some idea, or they give some input in relation to that. Anyway, maybe this is one of the problem of the online classes. Anyway, I want to take this particular observation made by Justice Deepak Misra. Don't go into the controversy that post-retirement job is, forget about this thing. Here in Mr. in state of NCT Delhi versus Union of India, in page number 58, this he mentioned one very nice thing. If it is visible to all of you, we can. Constitutional functionaries owe a greater degree of responsibility towards this eloquent instrument, for it is from this document. I want to highlight this particular words. That is, for it is from this document that they derive their power and authority, and as a natural corollary, they must ensure that they cultivate and develop a spirit of constitutionalism, which every action taken by them is governed by, and its strict conformity with the basic tenets of Constitution. Actually, in my class, at many point of time, the students, indulge with some sort of debate that in India we don't have the constitutionalism, because they cite number of examples. For example, mentioned that the criminalization of politics. Okay, first of all, they usually argue. First of all, they argue that the Constituent Assembly. First of all, the Constituent Assembly, it was the representatives, they are not elected by the majority of the people. Okay, so sometimes they try to the questions related to legitimacy of the Constituent Assembly. Subsequently, they give a sort of example. Even after 70 years, 75 years of the Constitution, we have been failed to this the socio-economic justice. Even the political justice. Even if we look into the political justice, politically, yes, we have achieved political justice, because we have given voting rights to everyone. Okay, one person, one vote. By way of this, we have achieved this political equality of the political justice. But there is a political justice also. And to answer to Ashutosh sir's question, that actually it is one of the failure, or it is one of the side in which we have failed in political justice also. That is the free and fair election. That is the criminalization of politics. Okay, it is against the concept of free and fair election. And if you look into the judgment of in relation to doctrine of basic structure, you will find that the free and fair election, it is one of the basic structure of the Indian Constitution. So it is a question in relation to the constitutionalism. But there are a number of laws. There are a number of laws. We can't say that there are no laws in order to curb this problem or to eradicate the criminalization of politics. There are a number of laws. Now, execution is not being done. That is why it is the observation. I have already mentioned that execution remains one of the problem in this country, and that is why it has been mentioned. That is the constitutional functionaries. Now, the constitutional functionaries includes the legislature, obviously the executive, and the judiciary. And there was a greater degree of responsibility. Now, here, actually, in a country like India, even at our institutional level, we sometimes find, that that is the idea of the collective responsibility. Okay, but the promise in a collective promise. Actually, these are quite vague. Collective responsibility is no responsibility at all. Or collective promise is no promise at all. What we have to do, that is, we must take greater degree of responsibility, and we must fix the responsibility, and fixation of the responsibility in the Indian context. Now, if I look into another judgment, that is RC Portugal versus Union of India, that is the same thing, which we have discussed point of time. The same thing, it has been reiterated in this particular case law. That is, mere existence of a constitution by itself, it does not mean or does not ensure the constitutionalism. It is the political maturity. Now, here I have, if I go back to my last slide, that is poverty, ignorance. Now, if the poverty and ignorance are very much persisting in a society, political maturity, obviously, you can't achieve. And since we can't achieve political maturity, then it is quite difficult for any particular state to attain the constitutionalism or constitutional culture. Not only that, it also mentioned in the judgment that the tradition of people that import meaning to a constitution which otherwise merely embodies the political hopes and ideals. Believe me, I am quite agree with this last line, because from my student, since the first day of my student life, I heard a lot of discussion about justice. I heard a lot of discussion about the women empowerment, environmental justice, human rights, etc., etc. Still, we are having the same problem. Now, the question is why? I think the answer lies here. That is, unless and until the people at large, because it is we the people of India. It is not that are corrupt. Politicians, they are not coming from the heaven. They are the very much part and parcel of the society itself. Now, we can't expect 100% honesty from a particular group of people, that is quote unquote politicians, when the other people of the society, they are also violating the laws or the norms on a routine basis. So it mentioned that unless and until the people participate in the entire discussion, in the entire of the constitutionalism that is following the norms, then obviously this will remain some sort of political hope. Even Navjit Singh Johar versus Union of India, very uh, important judgment, very much discussed and debated in recent times. Here the concept of constitutionalism, it has been interpreted from some sort of philosophical reasoning or the philosophical perspective, that the idea of constitutionalism, it is equal to, or it is quite similar to the idea of the rule of law. And the rule of law, it is the very ancient concept from Indian perspective, and that has been reiterated in Navjot Singh Johar versus Union of India case, where it has been said that constitutionalism is the modern political equivalent. Sorry. The ancient equivalent of ancient Hindu concept of that integrates religion, duty, responsibility, and the law. Now integrates the duty and responsibility and law. If I exclude the idea of religion in its ordinary sense, okay, obviously the term religion, it has not been used in its ordinary sense here. Okay, if I add this concept, that is the duty, responsibility and law, then obviously the idea of constitutionalism, it cannot be fulfilled or it cannot be effectuated only by the governmental organization. Actually, somehow, we have to, rather as the country as a whole, we have to end the constitutionalism. We will not follow the norms. We will not look into or go into the details of the constitutional perspective. We will not perform our duty. Rather, we will expect that the government or the different organs of the government, they will participate, they will discuss, or they will do their duty in an appropriate manner. Obviously, it is not going to happen. So then the question, now I have raised number of problems. And I also raised the question that how the constitution will work. Now here I want to quote B. Ackerman, that is he wrote one article in the 1987, that is Virginia Law Review, the rise of word constitutionalism. And here he expressed his opinion about the working of Indian Constitution, and he expressed, rather he was quite surprised while detailing the working of the Indian Constitution, and he mentioned that, listen, in spite of this number of drawbacks or number of problems, okay, into the Indian society, the Indian Constitution works very well. Okay, I want to just read this particular para. Okay, he wrote quite long. Okay, but I have taken only one portion. That consider India. Here is a country that, by standard criteria of political science, should never have been able to sustain constitutional democracy, mass impoverishment and illiteracy, linguistic diversity, bloody religious strife, all seems to be inauspicious addresses, and yet for half a century now, it has managed to confound expectations. Even if its constitution falls apart in next generation, how do we account for this success in sustaining a liberal democracy? He asks the question that yes, we have the number of problem. Every day we are accusing the different political parties that you have not done this, you have not, you are bound to do this. Okay, every day we are witnessing some sort of violence in the name of religion, in the name of language, etc., etc. Even then, there is no civil war till this point of time. Okay, there is no attempt. Okay, there is no attempt to break down the constitutional machinery, which may, I am using the word quote unquote may, that is constitution, which may exist in its weaker form. Even if I add to some sort of leftist argument, that the principle of the constitution, it has been violated, okay, or we are not following the constitutionalism, etc., etc. Then even one of the argument is will be, or it will remain, that the constitution is working, and it shows that, because when the constitution will not work, then the people will take the recourse of some sort of extra constitutional method, okay, or the method not provided by the constitution. And what that method would be, some sort of rebellion against the government, some sort of civil war, etc., etc. That has not been taken place in India. It simply means that yes, the constitution is very much working. In India, we have the constitutionalism. Maybe from the perspective of a legal history, the 75 years is nothing. It is a drop of water into the sea. That means it is a very fragmentation of time, but it is working. It simply means that as a nation, we have the constitutional commitments every time. Okay, whether the politicians who are basically criminal, if I agree to that point, okay, basically criminal, even if they are criminal, they have to take the oath in the name of the constitution. Okay, they have to follow, at least they agree. Primarily they agree. Whether they subsequently they follow it or not, that is a different thing. This is an executional problem. But principally, it is our fundamental constitutional commitments that we will follow the constitution and we will obey the principles of the constitution, and that is why the constitution is still working. And this is a very very long observation. I'm not reading the entire para. Okay, here D.D. Basu, what to say? That is the examining the principles of constitutionalism. That the constitutionalism is about the limits and aspirations. The constitution embodies aspirations to the social justice. Okay, let me add socio-economic and political justice, brotherhood, okay, and human dignity. And the tradition of the written constitutionalism makes it possible to apply concepts and doctrine not to recoverable under the doctrine of unwritten living constitution. The constitution is a living heritage and therefore can't destroy its identity. That means, what is my take from this part of observation from the writings of D.D. Basu, that in a written constitution, or in a country where they have a written constitution, actually it works just like a continuous reminder for the people who are in power or who are in the different organs of the government, that they have to follow these particular norms and they have to abide by the provisions of this. Now, if you when I asked about the challenges, actually, according to me, first and the foremost challenges to the Indian constitutionalism is the balancing the state, the state power, the state's power, or I must say, the authority of the state and the liberty of the citizen. Okay, because in the very recent past, if you look into, that is starting from Aadhaar, okay, Aadhaar to very recent one, that is Aragya Setu app, the individual liberty or the state interference, having a tussle point. So, according to me, this is the challenge of the constitutionalism in India. Actually, from the positivistic approach, or from the viewpoint of a positivist, state will impose the law, but from the individual perspective or perspective of a citizen, the state must be reliant, at least implicitly. Hobbes pointed out this thing, that at least I can, the state must do that, or the state must discharge its activities in such a way so that I can rely upon the state. Okay, it is not like that, I am always disbelieving the state. So the state must act in such a manner that the state becomes a reliant one. Now, I want to, I just came to the, the concluding portion. I started the very idea of the state, and if I am not wrong, India is as a state, and in order to run the state or the state activities with the constitutions we have, and the constitution, it has been given by we the people of India, that is, nations have attributed, or rather they articulate themselves as a singular political entities. Now the diversity, the diverse opinion, all of us, we talk, even in my discussion, I use the particular analogy number of times. But when we use the phrase, that is, we the people of India, actually we reduced ourselves, rather we articulate ourselves into a singular political entities, and that is the singular collective pronoun. And that means maybe some decision, some constitutional mandate of the constitutional mandate, or some decision of the government as per the constitution may not be acceptable to me, may not be viable, may be beneficial. But if it is as per the constitution, then I must abide to that. At the very last instance, I must say that so far the liberal constitutionalism, actually there are three versions of constitutionalism. Now obviously we are living in a modern liberal era. I will talk about the liberal constitutionalism. Now in this liberal constitutionalism, Sartre, he identified this following 5 elements, that in a liberal constitutionalism, there must be some sort of higher law, either written or unwritten, called constitution, and we have a constitution. That's the first criteria we have full. The second criteria, that there is a judicial review. I think there is no doubt about that. Okay, there is no doubt about that. Starting from the idea of judicial review in Marbury versus Madison, that is Justice Marshall of the American Supreme Court, when he opined or propounded the idea of the judicial review, and subsequently in Fletcher versus Peck, and in India it is Keshavananda Bharati versus State of Kerala, and the last one, that is the I.R. Coelho versus State of Tamil Nadu. Number of times the Supreme Court and the different high courts, in number of decisions, they exercised their power, and they tested that particular decision or that particular act of the government from the constitutional viewpoint, and that means the first criteria we have fulfilled, the second criteria we have fulfilled. And there is an independent judiciary comprised of independent judges dedicated to legal reasoning. Though there are few judges who conducted press briefing outside of the court, okay, though there are few judges who are not satisfied with the working of the government, okay, so there are few judges, or there are few judges who may not be agree with the policy adopted by the government, but still, considering the time frame, that is the 75 years, I think we have already established an independent judiciary. Though there are criticism, but all the political criticism is not acceptable to us unless and until some sort of concrete evidence. Because I think one of the very basic principles that mere assumption of bias is not acceptable. Rather, you must have the real danger of biasness. That is, the court reduce the criteria. Mere allegation is not enough. Rather, you must come with some sort of concrete evidence. That means the third element is also there. Possibly there are due process of law, and most basically, I think there is no doubt about the due process of law, and the process is so long that sometimes we are also fed up. Okay, we have problem with the process, that it is time consuming, too much technical, costly, etc., etc. But there is nothing to deny that we don't, we have a very due process, and the process, it is very much established by law. And there is a binding procedure, that is the law making procedure, and the law enforcing procedure. All these things are there. Now, even if I look this particular criteria as suggested by Sartori, these criteria are very much available. So quite safely we can say that we have the constitutionalism. Still, we have the challenges, because there are some allegations, there are some people, there are some organizations, there are some political parties who are casting their doubts upon this. But we can say that yes, there are constitutionalism is very much there. Okay, with this, I am concluding my session. Now, if any one of you have any question, any query, you may ask. Nirvaya case, okay. One question I found, that why the court took so much of time to provide judgment in case of Nirvaya case. Prashant Bhushan case, judiciary is active to provide judgment. It is as providing justice to the role of the Supreme Court in not important. Okay, very good question, but the answer, as an academician, obviously I can't give the answer to that particular. Yeah.
Sanjit sir, Ashutosh here.
Yeah. Tell me, sir.
I'm leaving so tomorrow, because I'm in the college, so I'm leaving now.
Okay. No problem.
Thanks a lot. See you tomorrow then, sir.
Okay, sir. Okay. Bye. As an academician, obviously, I can't indulge myself into that particular discussion. But yes, these are the challenges. First of all, the due process, it is to be applied, or the due process, it is to be applied for every cases. Okay. Now, in Nirvaya case, not only in Nirvaya, there are a number of cases. In case of civil litigation, if you make a survey to the Indian legal system, you will find that the average time frame of a civil litigation in India, it is more than 16 to 17 years. Okay. Now we are following the due process, and the due process is technical, lengthy, time consuming. We have less number of judges, we have less number of court. Okay, infrastructure is very poor. Now we have a detailed procedure you have to follow, and obviously it will cause delay. Now there are some issues which are very much there are some sort of stakeholder, or there are some, I must say, some sort of political angle. Maybe somehow they facilitated the process. Okay, that is why they got the judgment. I think you got your answer. Any other question? Any other question?
Sir, I have a question, if I may.
Yeah.
Sir, suppose we were talking about the constitutionalism, and somewhere it depends on the understanding of the people. As in, when the people will do not get what their rights are, government can do whatever to make fool people and to get away with that. So, do you think that a regime is there, a government is there, on which people have so much faith and so much belief that they do not even feel that the government can do anything wrong, no matter what they do? Let for a matter central government or the state government. So, does that thinking also poses a threat to constitutionalism?
Exactly. No, the government must always, it is my belief, my personal thinking, that the government must be put always in the, testing or the measuring rod. Okay, no government should be confident that whatever I will do, the people will accept it. Okay, if it is so, then it is a danger to the constitutionalism, because ultimately this will result to populism. Okay, now we democracy in its true sense, democracy does not mean the populism. Okay, democracy does not mean the populism. Sometimes, in the very recent past, whatever we have seen, actually it is not the recent past, worldwide there is a trend of narrow nationalism. Okay, actually at one point of time, we have gone for a, the globalization. Okay, but subsequently all of a sudden, if you look into the recent election, even in the last time the Trump won the election in only on the name of national. Okay, some other countries, in our neighboring countries also, now they are promoting the idea of the nationalism. Now this idea of nationalism, maybe the people are quite associated with it, they are some sort of they have some sort of different feelings to it. That is why it has been debated, that is, to whom you are giving the to vote. Are the people educated enough? Educated does not mean I'm talking about the so-called formal education. Are the people politically educated? Okay, now political education. Now, even one of the basic tasks of the political parties, is to make people politically educated. And what are the political parties they are doing? Some political parties saying, okay, hum mandir bana denge. Some political parties saying, okay, hum vaccine dila denge. Some political parties saying, okay, if I come to power, then I will give you electricity free, metro ride free. This is not the political education. Now, obviously, these are the challenges of constitutionalism. Okay, anyone else?
Thank you, sir.
Anyone else?
Okay, so if you have no question, we will wind up the today's session. So thank you so much for finding out time and devoting the time with us for this academic cause. And on that last note, we will continue tomorrow's discussion, because that is pretty much related to the same idea:
Yeah.
democracy, majoritarianism, and crisis for freedom. So see you guys tomorrow 4 p.m. Thank you so much, sir. Looking forward to host. Thank you, sir.
Oh, okay. Thank you. Thank you.